I am Jennifer Granick. I'm a lawyer. I'm the executive director at the Stanford Law School Center for Internet and Society. And I teach a clinical class there called the Cyber Law Clinic. And I also teach a computer crime class, which I think this year we're calling the Computer Crime Seminar, which I co-teach with Richard Salgado, who is in the General Counsel's office at Yahoo now, but is formerly with CSIPs at the DOJ. So I'm going to sit for my presentation today. I hope that's all right. And what we're going to talk about is the interrelationship between intellectual property law and vulnerability research and reporting. Okay. So, can you guys over there see me? Is this all right? No? All right, I'll stand. If I get tired, though, I'm going to sit. I don't want to cheat this side of the room. Okay, so I'm especially looking forward to this talk today for a couple of reasons. One is that I wrote a chapter for an O'Reilly book that's coming out called Security Power Tools, and my chapter is about these very issues. It's the first time I've ever published something that's amalgamated into book form, so I'm really excited about that. And I think it's supposed to be out in August later on this summer. The second reason I'm really excited about this talk is because I am announcing that I am leaving my job at Stanford and going to work at the Electronic Frontier Foundation to be Civil Liberties Director there. Thank you. The basis for that decision was that I decided that, at least at this point in my career, I wanted my mission to be not so much to make better lawyers, but to try to make better law. And I'll have more of an opportunity to do that and work on the issues that I like to do while at the EFF. So I'm excited about that. I have my new business cards and I have my new contact information on the slides later on. Okay. So what I want to do today, and the approach I want to take, is I want to take a kind of case study method and look at two instances where intellectual property law has been used to go after security researchers, and use those as case studies to kind of illustrate and hopefully illuminate some of the complicated issues in this area. Okay. The first case I want to talk about is Cisco and ISS versus Michael Lin, which some of you may remember from this Black Hat 2 years ago. And this is a situation where a researcher wanted to do a talk here at Black Hat about some security vulnerabilities he found in Cisco routers, vulnerabilities he had found while an employee at ISS. And the companies tried to stop him from making this presentation, and he quit his job, went ahead, made the presentation anyway. They then filed a lawsuit against him and also Black Hat for copyright infringement, misappropriation of trade secrets, and breach of contract. And I represented Mike in the civil aspect of that case. I have two URLs up here, which are links to my elongated story about the ordeal and the pleasure that it was to work on this particular case. And I'm also going to talk about HID versus IOActive, which happened at Black Hat Federal earlier this year. It's amazing how Black Hat just attracts these kinds of legal complaints, isn't it? It's kind of great. And in this case, some security researchers who had been doing work on RFID tags and had developed a way to spoof RFID tags to show that the technology is not secure, were threatened in a letter with a patent infringement claim. And I know that from having been involved in the case, and maybe there's some people from HID here in the audience, that the company claims that it didn't really threaten them and it wasn't really claiming patent infringement or anything like that. But I have seen the letter that HID sent to IOActive, and in the letter they say, based on our understanding of how your spoofer works, we believe your conduct may constitute direct infringement of HID's patents under 35 U.S.C. 271A. It lists some patent numbers, and it asks them to not publish any of the information. The result in that case was a bit different. HID did change their IOActive did change their presentation. whereas Mike Lynn went for it and ended up getting sued. So using these two cases, what I want to talk about today is copyright infringement. It's the relationship of the infringement law to the practice of reverse engineering, and whether the fair use doctrine saves reverse engineering for security researchers. I want to talk about trade secrets and how trade secret law and reverse engineering interact with end-user license agreements, terms of service, and contract law. And I want to talk a little bit about patent infringement, which I'll just tell you right off the front is something I know extremely little about. And then finally, sort of the overall question and problem of free speech and vulnerability reporting and how they go together. And we're going to do all this before 12:30, and I'm going to take your questions as we go. So let us proceed. Okay, copyright infringement in this case. Basically, in the Lynn case, one of the major claims was copyright infringement, and the copyright infringement claim wasn't particularly interesting. Okay, the copyright infringement was mostly based on the idea that the slides that Mike Lynn had for his talk were the slides that he had developed while an employee at ISS, and that these then were ISS's intellectual property, not Michael Lynn's intellectual property. It's not particularly interesting, and it's depending, I don't know what the slides looked like, but the thing that this claim illustrates about copyright law is that copyright law protects original expression. It doesn't protect facts or ideas. So it protects original way of expressing facts or ideas. So if you have facts sort of in a list, you can't really protect it. You can only protect the way you make the list in some kind of original sort of fashion. Oh, I have a question already.
When it comes down to the source code, my basic understanding is the source code itself is an artwork, like a book. But I get kind of disheveled when it becomes compiled code. Has there been discussions about that?
Yeah, so the question is source code and compiled code, how does copyright law treat those? And copyright law protects both source and binary and machine code. It protects both. And, source code's kind of obviously, for those of you who are programmers, you know that there's some amount of art that goes into writing it. But copyright law protects the compiled binary as well. And that's actually kind of good, right? Because one of the arguments we often make in other kinds of cases is that code is speech. Code is not just functional, it's actually an expression of ideas that computer scientists and other people can understand, and that it should be protected, or at the very least that First Amendment and free speech principles should come into play when we're talking about regulating code. So you can understand how on the one hand, if we're going to say code is speech and code deserves some sort of First Amendment protection, on the other hand, we're also going to say that's because it's original, and if it's original, and expressive, then copyright law is going to come in. The amount of copyright protection is going to kind of be on a scale, though, right? So something that's more factual and less expressive could still be protected, like, maybe a news article, and something that's extremely on the creative side and is all, originality, like, very few of our Hollywood movies today, those things would be kind of on the upper scale of protection. So it's a sliding scale, but it's within the realm of copyright protection. So the slides, in many ways, I hadn't seen the original ISS slides, but, we're imagining if you're talking about slides, you're talking about facts, and they're not particularly, most people's PowerPoint slides are not particularly expressive. My boss, Larry Lessig, is a kind of notable example of the opposite of that. He has very expressive PowerPoints, but I'm still laboring in the dark ages of PowerPoint use, so. The second copyright claim that they made was in the decompiled code for the Cisco source code. And certainly Cisco has copyright in the source code, as we just discussed, and in the binary too. And it probably has copyright in the machine code as well. If we're going to say, well, software is protected, it's going to be protected in all of these iterations. But what Mike Lynn did was he just used sort of snippets of this code in order to illustrate the points that he was trying to make about how he found the vulnerability and why it existed. So the question is, can you use some of these snippets of the code? Is that okay? All right, so copyright infringement protects software. When copyright law is protecting something, it gives the owner certain exclusive rights in the work, even though they distribute it or sell it or something like that. And those rights include the rights that I have up here, which I'm not going to read, but the rights are limited, right? They're enumerated rights that the owner gets to hold on to. And on the countervailing side, we have the rights of the public, and some of these are specifically statutorily identified. So one part of the copyright law says that it's okay to modify a program that you yourself legitimately own, right? So program mods are okay. But it's sort of a little bit narrow. You see, you can reproduce or change the program if the reproduction or adaptation is necessary for the program to be used in conjunction with the machine. So if I buy something and it's kind of obsolete and I want to modify it, or if I want to get some other kind of program and I want to make them work together, I'm allowed to do that under Section 117. And then we have the question of reverse engineering and what we are allowed to do there. So reverse engineering is generally protected by the fair use doctrine. And they've listed the 4 elements of the fair use doctrine here. So let's just talk a little bit for a moment about fair use and what fair use is all about. Fair use is a defense to copyright infringement. We often think of it as a right, sort of a right of public access, but it's got this kind of tenuous nature. Is it once you've infringed, you have this defense, or is it something that members of the public are entitled to do and is like sort of something that really needs to be protected in a much stronger way, like some of our other kinds of rights? And in our law in the United States, we have this kind of fuzzy 4-factor test where the judge sort of weighs all these factors and tries to determine whether or not something is fair use. It's not necessarily the way it has to go. In other countries, they have like a list. They just have this big list, and it's like, you can do this, you can do that, you can do the other thing. And the list is exclusive. It's like, do those things, other stuff we're not going to consider. That stuff's not fair use. So one of the nice things, and this is something that for those of you who consider the law or who are lawyers know, one of the nice things about a fuzzy test like this is it's so flexible, right? It gives you like room as new technologies come up or things evolve. You've got this great flexible test that can take all these factors into consideration and can evolve, right? Things can sort of change. The thing that's not good about a flexible test like this is that nobody has any idea what the hell is fair use, right? You don't know until you go ask a judge, and as we know, judges differ on these issues. So this is really hard for business people or for companies who are trying to make assessments about, or artists who are trying to make assessments about, am I well within the fair use doctrine, or am I kind of skirting on problems here? Am I going to get sued? What's going to happen to me? What will the judge say? And people don't really know. So you can have something like the book The Wind Done Gone, which is a sort of takeoff critique of the Gone with the Wind story written from the perspective of one of the slaves on the plantation. And at the trial level, the court said this is not fair use because it's taking the Gone with the Wind characters and the Gone with the Wind story and it's making a derivative work which is infringing. Only the copyright owner has the right to make Rocky 18. So, only the Margaret Mitchell estate has the right to authorize sequels to the Gone with the Wind story, and this is one of those. The Court of Appeals, other judges disagreed, and they said, no, we think that this is, sort of a parody. They're taking elements, but the elements are to critique the original work, and it fits in under these standards. So, that's a great result for fair use, but they lost first, so who knows? It's not necessarily clear. Okay, so the essence of reverse engineering and its relationship to the fair use doctrine is that, as I said before, right, copyright law doesn't protect ideas or facts. So if reverse engineering is required in order to gain some kind of access to the ideas or facts or functionality of a program, then any intermediary copies that are made as part of that understanding or part of that research on the original program are going to be fair use, okay? And there's a number of cases in this area, which I'll talk about in a little bit. But one of the main parts of the way that the case laws come out is that it shows that reverse engineering is not going to protect you from a copyright infringement claim unless you're legitimately in possession of the software that you're researching in the beginning, or if you use copyrighted code in your end product. Okay, they don't like that because the intermediary copies that you make to understand the program and maybe make whatever your new thing is going to be, those are fair use. But if you take pieces of the code and use it in your final product, then you're just copying, and the courts don't like that. Okay, so let me talk a little bit about the cases, and then if you still have your question. Okay, so one of the cases from 1992 is Sega versus Accolade. And, a lot of these reverse engineering fair use cases take place in the realm of gaming. A lot of gaming cases, and this is one of them. This is a Ninth Circuit case. The Ninth Circuit's our circuit here where we are, and also in California. Nice and big circuit, lots of law. And lots of video game companies and lots of internet companies. So persuasive on these kinds of issues because they see a lot of them. And in Sega, the court said reverse engineering is a fair use when there's no alternative means of gaining an understanding of the ideas and functional concepts in a piece of software. So it's okay to do this. And this case then led to Sony Computer versus Connectix. Now in this case, what was happening was Sony had a relationship between their player and the video games. And another company wanted to build an emulator that would play the video games on the computer, so you didn't need to buy the Sony box. Well, you can see why Sony wouldn't like this. They want you to buy the box and buy their video games because those two things go together. And we see this a lot, right? I mean, we see this kind of tying. This actually is a real interest of mine. We see this kind of tying between products all the time. And we see companies often trying to use various types of intellectual property law to get legal protection for a business model that ties the first thing you buy to aftermarket goods or services, right? So you buy your Hewlett-Packard server or whatever, and if you want to get it fixed, you've got to get Hewlett-Packard maintenance, right? And then you have all these third-party maintainers that were and servicers that were really big in the early 90s, and then Hewlett-Packard started putting in lockout codes and not giving those codes to the maintainers. And I've represented people. I represented a guy who was criminally prosecuted for having those lockout codes reverse engineered so that he could continue in his business of being a provider of upgrades and service to Hewlett-Packard servers. Not with a happy ending to that case, but I can talk about that more if people are interested. You can see it with like in the DMCA context, Lexmark sells their printers and they want you to buy the name brand Lexmark printer cartridges, and they have lockout codes that either make it impossible to put in a different printer cartridge or degrade the performance of if you use other printer cartridges. You have, meanwhile, the competitors who want to compete in the aftermarket services are reverse engineering these codes and trying to provide generic brand printer cartridges. Or in another area, which I have also been really involved in the cell phone area, you've got the cell phones, they're locked to a particular network, so they sell you the cell phone really cheap and they want you to then buy the service and keep buying the service from your particular provider. They lock the phone so that you can't then take that phone to another network, even though technologically the two should be compatible. And this case was no different. This was just an earlier version of this kind of tying arrangement. And what Sony said, hey, you're reverse engineering and then you're creating this emulator and you're violating our copyright in the code we use to run the PlayStation. It was a PlayStation then. So what the court said there was, they went through the fair use factors. It's sort of an really interesting kind of analysis, because if we go back, I'll just show you the fair use factors. The last factor here, the effect on the market or value of the copyrighted work, is the most important factor really in the fair use analysis. And it makes perfect sense if you think about it, because the idea of copyright law is that we want to assure to the creator the economic benefit of their creation in order to, incentivize them to make cool new stuff. That makes perfect sense. But the way the term is phrased, it doesn't really answer a lot of the difficult questions that you might have. One of them being, does the Sony emulator, or does the Connectix emulator interfere with the market for Sony products? Well, it might not interfere with the market for the Sony game products, but it definitely could interfere with the market for the PlayStation, because people will play the games on their computer instead of having to buy the PlayStation and play it there. And so, the question is that the kind of thing we're talking about? Is that the kind of profit protection we're talking about? Similarly, you could see how some kinds of reverse engineering or products, particularly if you're pointing out that a particular piece of software is insecure or vulnerable, could interfere with the market for that program, because now people know that it's not as good as they said it was, and maybe they don't want to buy it. Is that the kind of interference with market that we're worried about? And what the court said in Sony versus Connectix is, no, that's not the kind of thing we're talking about. We're talking about people capitalizing on the creativity that goes into the copyrighted work, not interfering with any kind of like revenue stream or business model that the company may have come up with, okay? And that's really important. That's an important principle that I think, as the laws progress, to some extent, we're kind of losing track of. I think we're kind of developing towards a world where we think, hey, that's their business model, that's how they make money, they should be entitled to continue to make money that way. And we can talk a little bit more about that too. But regardless of this, you've got to be legitimately in possession of the software. So in Atari games versus Nintendo, in that case, the company that was doing the researching lied to the Copyright Office to get a copy of the source code. So they had lodged the source code with the Copyright Office to say, like, when they registered it, and the court said, and then the researcher said, we want it for this, and the court said, no. When you got it through that kind of subterfuge, you were infringing. There's another case, DSC, I don't have it on my list here. There's another case, DSC, Communications versus Pulsar. I forget the name, but basically this was about reverse engineering a kind of phone switch network for inside a company, and they basically used like some kind of shell third-party company to buy it, because the main company wasn't selling its product, restricted selling its product to any of its competitors, exactly because they didn't want the competitors to have access to it to reverse engineer it. Okay, this isn't so strange, right? Because when you buy software, there are some companies that sell software with end-user license agreements that say, you promise you're not going to use this software to compete with us, or you promise you're not going to use this software you're not going to reverse engineer it, you're not going to do benchmarking, you're not going to criticize it, you're not going to report on it, and we're trying to, basically you're attesting that you're buying it for purposes, to use it for purposes with which we agree. And we have some questions about the enforceability of these sorts of contracts, which we'll talk about a little bit later on. There have been some state attorney general's offices that have gone after this kind of project or process, this sort of protection that they're looking for. But, the status of the enforceability of these kinds of licensing agreements is still sort of up in the air. And, if you are a competitor, if you are a researcher, and the company doesn't want you to have access to the code, it makes your work a lot harder. And I think that it's a issue that hits web researchers, people who do that kind of research, particularly hard, because let's say you're doing research on a particular piece of code, you can buy the code and maybe the EULA is not enforceable, or you can get a copy of the code, you can buy the software from somebody else, and then they delete their copy, maybe that's legal and you're okay. There's some ways you can get access to the code without having any kind of controls necessarily by the owner. But if you're researching, let's say, a particular implementation of something on a website or something of that nature, not only does the website owner have perhaps, maybe not, but copyright in the code, but they also have a lot of legal control over their boxes. It's their servers. They have control over those servers, and to a large extent, the law thinks that they have the rights to control the terms of access to those servers. So there'll be a terms of service or something like that, which will say you can access my website, but not for these purposes. So VeriSign had a terms of service that said you can search for who is data, but you can't search for it if you're a competitor. Or a site that had information for employees of Hawaiian Airlines had a terms of service that said you can search, and log on here, but only if you're a laborer, labor person in the Hawaiian Airlines management is not invited, right? And then you have all these sorts of cases where these kinds of, you even have cases where there's no terms of service, where a guy who used to work at a travel company left that company, went to work for a new company, and helped the new company develop a way of spidering or crawling the original travel site to find out what they were charging for various cruises and vacations and stuff like that, so that they could set their prices competitively. And the court said, well, when he accessed his ex-employer's computer server for this competitive purpose that was contrary to the interests of the first travel site, that was also unauthorized access, because they would never have given him permission for that, and he probably knew that they wouldn't have given him permission for that. So this idea of permission and needing to have the permission of the copyright owner or the permission of the server owner in order to do the research that you want to do is a very serious and potentially limiting issue. Okay. Did you still have your question? And then I'll go to you.
So we talk about permission from, let's say, the software vendor. If they don't give you permission, but that's the interoperability and privacy testing, security testing. Do they have to give you their permission, even though it's an exception to the copyright law?
They don't have to give you permission. His question was, because you're allowed to reverse engineer under copyright law, do they have to give you permission? And they don't have to give you permission. And the reason why is because of this nature of fair use, not as a right that you have, but as a defense to copyright infringement. So if you infringe, you can say, well, it was fair use. I was reverse engineering for fair use. That's what a defense means. If you had a right to reverse engineer or a right to fair use, then you would say, you're not allowed, one of the implications of something being a right versus just a defense is I would say, I have a right to do it. You have to give me access because I'm entitled to do it. You guys see that difference? I didn't explain it well the first time, but it's seeing that difference between something being right or defense. Yes, sir?
Will you comment, please, on the difference between actually purchasing software and purchasing a license to use software?
So the question is about the difference between purchasing software and purchasing a license to use software. This is one of the great unanswered questions that's developing still in internet law that we're still kind of trying to grapple with. So the idea is that, so in law school they'll tell you property is a bundle of sticks, right? It's not one thing or another. It's like a bundle of rights. And the question when you transfer property is, which of those sticks that I have I then given to you? Okay, so normally if I sell you something, I might give you all the sticks, and you get the Harry Potter book, and, let's not use a book, that's wrong. You get what's something that is totally up to you. Let's say it's your, car or something like that. You get the car, and if you want to beat it up with a sledgehammer or take it apart into parts or paint it purple, you can do whatever the hell you want with it. And I, as the seller, I don't have anything to say about it. When I sell you a book or software, copyright law says if I'm the owner, I retain some of the rights. Okay, so maybe like CompUSA doesn't, but the copyright owner holds on to some of the sticks. CompUSA gives you all the sticks, and you can do anything you want that doesn't violate copyright. Well, licensing versus sale encompasses these same kinds of issues, except instead of the sticks that are retained being defined by the law and limited defined by copyright law and limited by fair use, what sticks are retained is defined in the licensing agreement and could be more or less than what copyright law generally would allow. And depending on whether the court enforces that license, there might not be any kind of sticks that are retained by the public or given away regardless of what the seller wants. So I might say, you know, in my license, no fair use or no reviewing or no benchmarking or something like that. And if those licenses are enforceable, then I get to hold on to those things. I can say, you know, you can only use it for these purposes. So it's really, you know, there's kind of a broader battle going on about the difference between owning something and being free to do with it what you want, what Professor Ed Felden calls the freedom to tinker, you know, or, you know, if you read Make Magazine, kind of the Maker Manifesto. I want to open the box and be able to see what's in there and tear it out and mod it and do whatever I want with it because it's mine, and that's what freedom means, that's what property means. Or this kind of license world where everything is transferred but with conditions that control you and control what you do to make sure that you're never using any kind of software or property in a way that, you know, makes the owner mad. And legally, there was a real push in about the, I would say maybe the early 2000, like late 90s, early 2000, to try to change contract law to make these licenses and the way that software is sold really like very legally approved and enforceable. And so some states passed a version of this set of rules about commercial software license sales called UCITA. And then after a couple states passed it, there was this huge like uproar, and people were totally against UCITA because they saw that basically what it was going to do could be to supplant copyright law, which is supposed to be this balance between fair use and incentives, and just have it be whatever the seller tells you is what you have to do, and you're subject to that whim, and there's nothing you can do about it. And so the UCITA movement kind of got squished down, and we haven't really gone and answered the question fully about what exactly all these licenses mean. So my Wired column last Wednesday was about EULAs in terms of service, and you can read it. There's some interesting cases in the area now, but you know, we've seen, just to kind of generalize, we've seen cases that have said, hey, there's a license, you bought it, you kept using the product, you obey the license, that's what a contract is. Then there's cases that say, you know, let's be real, people don't really have a choice when they buy something with a license. It's a take it or leave it sort of thing. You don't get to call up Microsoft and say, you know, on page 340 of your EULA, I really don't like the term that says that I'm not allowed to, you know, use the product in this particular way. Can we talk? I'll pay you an extra $2 if you know, take that term out of the EULA. So because it's just this take it or leave it kind of thing, there's something that changes the balance of power between the seller and the customer. And so we're going to look at the terms of the license with a little more suspicion. And if we find the terms are oppressive or bad in some way, then maybe we're not going to enforce them. And we've seen a couple cases like that, particularly with refusing to enforce arbitration provisions. Because a lot of states don't like these arbitration provisions. They enforce these, you know, kind of very pro-consumer rules, and then these arbitration provisions say, oh, even though you live in California and you've got this nice consumer protection law, you promised to do arbitration. And the California courts are like, no, I don't think so. Our legislature has decided that this is what we want our customers to have. So we're not going to enforce these EULAs, all the way to some enforcement by the New York Attorney General's office, who has sued a couple of companies that have particularly anti-free speech provisions in their EULAs, where they say, you're not going to criticize this product without written permission from us. And the Attorney General's office has sued some of these companies, and they've never, I don't think they've had courts rule on it, but in every case the companies settled and said, okay, we're not going to put that in our license anymore. So you can see that the effect of a license is quite a bit different from the effect of like, oh, I'm just selling it to you and it's a car, or even I'm selling it to you and it's the Harry Potter book and you're not supposed to take photos of it and then put it up on the internet. But if you want to rip it up or resell it or make it into like a coaster or, you know, whatever you want, wear it as a hat, you can do whatever the hell you want with it. So there's a very, very big issue. Okay, where am I going? Okay, so in Michael Lynn's case, just to sort of close this part of it out, I think this is sort of classic fair use. What do you need to do when you're doing reverse engineering to ensure that you're going to fall into the classic fair use thing like I think Michael Lynn did? although of course he did still get sued, but it worked out, pretty well in the end. Legitimately obtain the program. Don't infringe in the final product. Make sure that you're making the copies because you're trying to understand the product that you're working on, that you're reverse engineering. And don't steal the software you got to reverse engineer. Okay, so that's sort of important. Not super interesting intellectually as a legal matter, but really important and an important thing to defend because of the obvious impact it has on computer security. Okay, so we talked a little bit, yeah.
Just the part where it says legitimately obtain for the different exceptions. The cryptography one says you must obtain the copyright item legitimately. A lot of others say the security one doesn't say whether we need it or we have to need it.
Okay, so his question, he's saying, well, in some of the exceptions, he's talking about an exception for encryption and an exception for security. And I want to make really clear, and I think what you're talking about is the DMCA anti-circumvention provisions. I am not talking about the anti-circumvention provisions here, okay? What I'm talking about is regular old copyright law. I'm the owner. I own the copyright. I sell it to you. There's rights I retain. There's stuff you can do. What you can do is reverse engineer. Reverse engineering's fair use, but there are cases that say you don't get to avail yourself of that defense if you do. Where am I? Yeah, if you do these things. These things will impair your ability to raise the fair use defense. Okay, the DMCA is another statutory scheme. People have called it para-copyright. It doesn't actually have very much to do with copyright, the way that we've implemented it here in the United States. So I'm going to talk, I wasn't going to talk that much about the DMCA because it's really complicated, but basically, let me see, I know I have a slide on it, so let me just go to there so you can kind of see it. Here we go. Okay. So basically, the anti-circumvention provisions are a different part of copyright law. It's under the Digital Millennium Copyright Act, but it doesn't have anything to do with copying, right? This is a statute that prohibits basically cracking a technological protection measure, which you can think of as DRM, that controls access to a copyrighted work. It also prohibits trafficking in a tool or service that helps others to crack or circumvent a TPM. Okay? Notice that it doesn't say to copy the copyrighted work or to do any of the things that the copyright owner is entitled to do and you're not allowed to do. It's just to access the copyrighted work. Okay? So, for example, if the copyright owner doesn't give you authority to do, if you don't have authority to do something, and it gives you, but you're still getting access, it's sort of wrong. So take a look at if you're familiar with the DCSS case. This is a case about DVDs, right? And people have the right to, there's nothing in copyright law that stops you from playing your DVD that you've legitimately purchased on any DVD player or on your computer or anything like that. That's all sort of okay. Under copyright law, you're not making a copy. You're not doing anything that infringes the exclusive rights of the copyright owner. But because they put controls on how you access that work, i.e. they region code. You can only play these DVDs bought in this country on these players. And they don't allow or license the decryption technology to players that also are copiers. They didn't used to, like your computer. Or they want you to not be able to skip past the commercials or that sort of thing. These are controlling access to the information on the DVD, and the DMCA kicks in. Okay, so it's not really copyright. This law has a couple of exceptions for reverse engineering, encryption, and security research, and those exemptions have very specific elements that you have to meet in order to get to those, in order to have those defenses apply to you. But that is different from what I'm talking about here. So this is important. It's important to security research. I've talked about it before, but it didn't come up in either of these two cases, and it's complicated, so I'm not going to talk about it more today. But you'll see, for obvious reasons, the same kind of factors that courts and Congress think are relevant in this one area to when you're a good guy and when you're a bad guy are also carried over in fair use, are you a good guy or are you a bad guy? And if you stole the code in the beginning, they don't like that. That makes you more of a bad guy, right? Whereas we all know sometimes there's reasons why you have to get something kind of nefariously, like the company has a policy that they don't sell anything to anybody who is trying to take a critical look at it. They only want yes men to have a copy of their thing, right? Okay. So maybe stealing is too harsh. So as we've discussed kind of through these examples, reverse engineering is generally legal. It's generally thought of as a defense as opposed to a right. And it has some limits by contract law and by the DMCA anti-circumvention provisions. And we've seen how like the licensing can kind of come in, because if I say, well, you're not allowed to purchase this or something like that, you can be, you can be limited in what you're allowed to do with the thing afterwards. So how robust, really, in a world where there is so much licensing, as the question indicated, how robust is reverse engineering, and how legally protected is it, given that there's all these other kinds of doctrines that sort of come in and infringe upon it and can control what it is that you do. Okay. We talked about the DMCA. Oh, let me just mention one thing here. So one thing about the DMCA I just want to point out is that it's been successfully used to threaten researchers in the past, and I can go through the list. Ed Felton's team, when they were looking at SDMI, the Snowsoft guys, when they were looking at HP. I mean, there's a ton of examples of how it's been successfully used to threaten researchers in the past. But we've never gone all the way to where there's a court case and people who are doing research were actually sort of been upheld in that way. And we're also seeing a little bit of cracking in the DMCA hegemony, the power that this statute has had, in a couple of ways. One is that there are some knowledgeable members of Congress who want to change the DMCA. They're beginning to realize how broad the reach is and thinking like, well, maybe we went a little too far in the way we phrased it. Our goal was to protect, the Disneys of the world and encourage them to put their stuff out on, the network in digital format. But what's ended up happening is that we're seeing printer companies using it to go after aftermarket printer cartridge vendors. We're seeing garage door companies using it to go after the aftermarket garage door clicker sellers. We're seeing telephone companies or wireless providers using it to go after people who flash and resell cell phones. And is this really what we want to do? Maybe not. So on the one hand, you're getting a lot more questioning from Congress about the ongoing legitimacy of the statute. On the other hand, you're getting a Copyright Office issuing more exemptions to the statute than ever before. Well, not more than ever before, but kind of liberalizing the circumstances under which they'll issue one of these exemptions. So I just got one in the last round of exemptions for the cell phone unlocking, and there were a bunch of others too. Film professors got one to be able to show snippets of their movies to their classes. There's some exceptions for archaic software that's on no longer functioning dongles. There's a lot of interesting exceptions if you're interested in taking a look at that. But this statute, which is been a real problem for researchers and a real source of fear, I think, for some overseas researchers, may be losing some of its support and power. Okay, trade secrets. This is another kind of intellectual property, and a trade secret is basically something that is valuable by nature of it being secret, and that the companies tried to keep secret. Well, in the Michael Lind case, what was the secret, right? So they charge him with trade secret violation. What's the secret? He had access. He didn't have access to the source code. He had the binary code. They sell the binary code. You can just get that. So if you decompile publicly available code, are you getting at any kind of secret? Well, no, because it's not secret because they're selling it, and you're not misappropriating it because you're not using any kind of improper means to get at it. Reverse engineering or independent derivation is not going to be improper means. So, what's the secret? And the one question is the product flaw itself a secret? And I have had, and people that I've represented, I've had many attorneys for vendors that have flawed products call me up and say, the fact that it works in this particular way and that's not very secure, that's our secret. So don't disclose that. Which I think is sort of, shocking. In 2003, the company Blackboard claimed trade secret violation and got a temporary restraining order and prevented some researchers from disclosing security flaws in that company's, I guess there were door locks or door access devices at Interzone 2 in Atlanta. So, you can imagine if we had this same rule with cars, it's like, okay, when you rear end the Gremlin, it blows up, but we don't want you to know that because it's valuable information because it's secret. If people knew it, the value of our product would drop. So, let's not do that. And, one of the problems is that, other than kind of that you have overzealous attorneys, but you also have judges who are not particularly familiar with software and sort of weird, and so, you worry that somebody might actually believe this as an argument. Okay. Any question about that? Yeah. Yes.
There's clearly a real distinction between the software-related laws of like PlayStation games and computers you have to buy with your own box. And those secrets, like rendering a Gremlin puzzle to blow up, where it's an issue of either physical or business continuity health. If the courts expressed any real opinion regarding the fact that issues of exposing security flaws or physical safety flaws are for the greater good, and therefore it's a bigger priority than just $2 box on the shelf.
Yeah, so his question is, okay, there's kind of a big difference between like, can you play your PlayStation game on your computer and your car's going to blow up? So do the courts recognize the nature of this distinction? And I think the answer has been both sort of inherently or sort of subtly, yeah, but actually no. So let me sort of, kind of illustrate. I think that, in any case that you try or you go forward with, especially when you're trying to change the law or the laws a particular way, you want a set of facts where the court's going to be like, if I do this, which is the kind of what the law tells me to do or is sort of the easy path or something like that, all these other horrible things are going to follow. And I don't want to be the guy who says that, sorry, your Gremlin blew up, but I thought it was a trade secret, because the judges are people too, and, they got to go home and sleep at night as well. So to some extent, some of this is taken into account. That's one of the reasons why, it's very hard to win. I think for now we've had some trouble winning civil rights cases about the right to reverse engineer and the right to fair use and making fair use so robust and important when we keep raising it in circumstances that have to do with copying DVDs and video games, because while, normal people care a lot about their media and their music and their entertainment, courts are like, what the hell, who cares, right? Whereas with a car, you would really care. And there's a paper that one of our fellows from last year wrote, David Levine, about the problem of trade secret law protecting things or security vulnerabilities in some of our kind of more critical infrastructures. That's probably not the right word, but things that are important to our health, like cars, or like the Cisco routers, which are not just computers, but run the backbone of the internet. So if you have a vulnerability that allows you to execute arbitrary code on those routers, that's pretty serious stuff for the internet. Maybe people should know. Or with voting machines. And that's one of the areas where we're really seeing this trade secret versus public right, battle going on. What could be more important? These voting machines are like the mechanics of democracy, right? And yet they're out there with this proprietary code that the companies don't want you to see because it's a trade secret. So how do we know whether it works? And if we enforce trade secrets versus kind of the public's access or the public's need to know, when we have these like very important matters, then what are we protecting? Now the thing about trade secret law is that it differs from copyright law, and that copyright law is always, at least given lip service to trying to have this balance. You've got the incentives, and then you've got fair use and the public right of access, and these are supposed to be kind of in balance. We recognize that there's some public right. With trade secret law, we don't really have that kind of thing. You know, a lot of the stuff that's accommodations for the public interest in copyright law, we don't have in trade secret. Trade secret, it's like you tried to keep it secret, it's valuable to you, it's secret, there's no time limitation, right? The Coke formula is still trade secret, and you know, it just sort of goes on like there. So where do we have any room in the doctrine for this very important issue of maybe keeping this secret is harmful to the public interest, right? And so that hasn't actually been fully developed or fleshed out yet, and it's something that we still have to fight over. So it's still a unanswered issue. But if you're interested in that paper, it's on SSRN, and the author is David Levine, and he kind of goes through a couple of these examples talking about the way trade secret law might evolve and the limitations of how it is currently, specifically for these important matters of public interest. Okay, well, I haven't talked about HID at all, but let's sort of, so to crystallize, you know, one of the main questions that I have is the question of the impact of copyright law and or rather contract law, and what a EULA or a terms of service or a non-disclosure agreement can stop you from doing that you ordinarily would be allowed to do, okay? And there's a big difference in some of these things, because one of the things we say in the law is like, you know, if you have a right but there's no remedy, what's the good of having the right? You know, if you say, well, yeah, you're entitled to fair use, but if somebody denies you it, well, you're not allowed to do anything. It's like, well, you know, that isn't so much of a right. What the ramifications are matter. So if I have a EULA or a terms of service, a contract that says you're not allowed to do something, and as a result, it takes away my right to fair use, and now I'm a copyright infringer. That can get you into statutory damages, which is like set forth damages in the statute regardless of how much harm you actually did. Some kinds of copyright infringement are criminal, and you know, maybe you could get in trouble for something like that. That's kind of serious. Whereas if you say, well, you know, I had a contract, and this contract is something that said you weren't going to reverse engineer, but you did. But I'm not going to say that you violated copyright law as a result, because copyright law says you can reverse engineer. We're not going to look at the contract as impacting that decision. The contract's just a contract, and you breached a contract. Well, breaching a contract is, you know, business people out there know, it's something that happens. And there's no kind of moral opprobrium that goes along with breaching a contract. A contract helps kind of level and mitigate risk. And if I feel like by breaching the contract, I'm going to go do better somewhere else, all you're entitled to is what your expectation, usually financial expectation was. I pay you off and I go make my deal with the other guy, and if that's economically efficient for me, then that's what I'm allowed to do, and I'm not going to go to jail, and I'm not going to get punitive damages, and only in very rare cases am I going to be forced to actually go through with my end of the contract. Mostly just paying you off is fine. It's economically rational, it's okay. So there's a really big difference. You know, one question when you say, well, somebody did something wrong, one really important question is, well, what does that mean, right? How severe are the penalties? What legal regime's triggered by the fact that you did something wrong? And so that's my questions about the contracts. I'm not saying contracts are bad, but I'm saying if contract law takes away rights we have under reverse engineering or fair use law, or rights we have, you know, under other sorts of statutory schemes, and then throws you into like a criminal or a severely penalized economic context, that kind of extra sucks. So here's some cases on EULAs. These are a little bit old. I cite two new ones that are very interesting in my Wired column that was up on Wednesday. Okay, so patent infringement, and we'll talk a little bit about HID, and then I'm going to stop in like 5 minutes so we can just do some questions. So here HID claimed that there was patent infringement, or at least suggested that there was patent infringement, and you know, for patent, you have to violate it, you have to make, use, sell, or offer for sale an invention that's described in the patent's claims and without the patent owner's authorization. It's different from contract in a lot of ways. One, it's shorter. Two, it does protect ideas and functionality. And three, it requires you to disclose these, you know, when you register for it for the patent office, so that after the term of the patent protection is over, the public gets to take advantage of your brilliance in having created this great new machine or device or innovation. So, you know, was this a valid threat? Well, it's like, well, you have a reader or a RFID reader, and my reader or my spoofer operates in the same exact way, then in theory it makes some kind of sense. So it's like, ooh, that's kind of scary. Although one of the nice things about patent infringement is that you don't get statutory damages, you only get actual damages. So you have to see like what the harm really is, and if there's no real economic harm, i.e. I'm not piggybacking on your genius in order so that I can make money, then you're not going to really get any kind of real damages there, and so the downside's pretty low, which, as I said before, is a great question to ask, because it's like, oh yeah, you violated the law, but guess what? You get the slap on the wrist versus you violated the law and you're going to get statutory damages, and it's going to be trebled because it was willful, and now you're bankrupt and you're totally unhappy. Okay. So this issue of patent law raises some other really, and this sort of restriction raises some other really interesting questions on the other side, right? These copyright owners or big companies aren't the only people who are benefiting in a potentially scary way. So this was brought to my attention a couple of months ago, this intellectual weapons program or effort company. I don't know exactly what it was. The website doesn't exist anymore, but basically, this was a group that wanted to do security research, find vulnerabilities, patent the fixes for these vulnerabilities, and then make money by selling the fixes to their customers and not letting either the vendors or non-customers fix vulnerabilities, patch vulnerabilities, because that would be infringing their patents. Okay, so basically, it's like, let's flip it on the head, right? Here you have vendors that are the bad guys, right? Who are like, oh, you have to pay us, or you can't tell anybody our stuff is insecure. And then on the other side, there's still more bad guys. It's like, oh, well, two can play at that game. Guess what? You're going to say we can't show how we researchers can't show how your RFID reader is insecure. Well, guess what? We're going to find out how to secure it, and you're not going to be allowed to secure it unless you pay us. It's sort of, part of me is attracted to that, to the evil brilliance of it, and part of me, the sort of older, more sober part of me is like, oh God, that would be sucky if that was true. So, this was their thing. They said, well, we're going to encourage our customers to seek a license and apply our solution, and we will enforce our IP rights if that's what's necessary. So, basically this bites both ways. Whether you're a vendor or you're a researcher, you have to be really concerned about what these issues are, because it impacts computer security overall. And, it's a serious concern. On the one hand, we want to protect what intellectual property is designed to protect. On the other hand, we don't want to get ourselves into a situation where everything is so proprietary that we can't deal with the public infrastructure, car blows up kind of issues, that we can't have access to patches and information about, how we can keep ourselves secure, that we don't know these things. Okay, just a tiny little bit about free speech. Yeah, it deserves a minute. Free speech is our First Amendment. It's most people's favorite amendment. It's not necessarily my favorite amendment, but it's our most robust one still, so we have to give it credit for that. And one of the real questions is, how does speech play into this? Because a lot of the stuff that we're doing, and a lot of stuff that by either pointing out how voting machines are insecure, or stuff that you guys are doing by saying, there's flaws in the Cisco router, or RFID is insecure, is basically, and saying like, look, I'll show you, is basically speech. It's saying, this is for real, man, you got to pay attention to it. And so, as I said before, we treat code as speech. Some kinds of actions are speech. Burning the flag, it's an action, it's functional, but it also has a speech or a communicative element to it, and the First Amendment protects it. So how does the First Amendment kind of play into all of these things? Well, it's a relatively novel area of the law. We haven't really thought all that much or done all that much work about how the First Amendment and speech protections play into as a limitation on play into IP law, intellectual property law, or limit intellectual property law. And so we've been doing kind of a really bad job in many ways of making sure that there are robust speech protections in these areas. We've seen a couple of cases in the copyright realm, mostly I think because of the quixotic efforts of my boss, Larry Lessig, who really wants courts to begin to see that, copyright law impacts speech. And I think he's done while his court cases have gone sort of generally badly, I think he's done a great job of making judges more aware and making the public more aware that copyright is basically a limitation on speech and has to have, all the kind of review and limitations and restrictions to allow speech to flourish. What I think I've pointed out with these examples is that it's no less true for other areas of intellectual property law, and it's a concern. But no element, if you look at the defenses in these charges, no element of defense in these charges doesn't violate free speech or doesn't impact the transmission of information, regardless of how important it is. So I'm going to take questions. That's my current information, which I think maybe many of you have. And this is going to be where I'll be until the end of August. And then after Labor Day, I changed to my new job, and that's my new information at my new job. So I'm going to take some questions, and just raise your hand, and we'll call you. Any questions? Yes, sir, in the back. Can you say it just a little louder? I'm sorry.
Dynamically linking to binaries distributed by someone else and then patching them in memories, not distributing your code. Is that considered work under limitations on not using the original work afterwards?
Is your question whether linking is infringement or
Dynamically patching someone else's code?
On whose machine? Okay, so someone else's code is on your machine and you're patching it. Okay, I think that would be fall under 117 program mods. I think that, and you would be saying I'm patching it to make sure it keeps working for me and it doesn't, mess me up. I think that would fall under 117. Now, mind you, I think what have I read? There's 3 cases or 4 cases in all of software history on 117 and exactly what it means. But I think that would be pretty clearly under there. You're not copying anything, right? You're modifying it. Maybe it's a derivative work, but it's derivative and you're holding on to it. Now, it might be a different story if you patch somebody else's code and then you started distributing it and saying, guess what, mine is better because it's improved with this patch I wrote. Most of what depends on how much of what you're distributing. That wouldn't be as good. Yeah. Okay. Yes?
The only thing I would say to that is but for the fact that he's actually probably violating the
Yeah, so that's a great point. Thank you. But for the fact that he may be violating the EULA, which might say, you can't do something like this. And so then my question is, well, if you're violating the EULA, does that mean that, guess what, 117 doesn't apply to you? You don't get to use that as a defense and now you're a copyright infringer? Or does that mean you violated the EULA and they can try to go after you for contract damages? And then the question about contract damages is, does the EULA say, if you violate this EULA, you owe us $1 million? Well, contract law is filled with doctrine to control that, to make sure that people who enter into contracts aren't getting a windfall as a result of breach of contract. So, that's... What do you mean obligation? Like obligation to your company or obligation to him?
Obligation to him because he's licensing it and he expects a certain...
I don't know that that's true. I don't know that the vendor has a continuing obligation to us because, we know tons of vendors that sell you something and then they go out of business, right?
Right, but this is my point. This is something that in technology, computer cases I've never seen. How can companies have it 2 ways? I want to sell him the software because I want control over it. Now I don't want to control it anymore.
Yeah, so
It's like a rental car. If I get in an accident with my car because my brakes are worn, that's my fault. I should know to fix the brakes. If I rent a car at Hertz and the brakes are gone, I get in an accident, Hertz is responsible. Nobody has done anything else trying to get the software
Yeah. So the question is, why is it so one-sided? It's like the customer has all the burden, and the vendor doesn't have to maintain the software or even assert to you that it's secure or anything like that. They can just sell you whatever crap they want, and then you're kind of stuck with it, and that's it. So why is it one-sided? Well, we're individual people, and they have, big companies that have a lot of money. That's one reason. Another, maybe more legit. I don't want to be Machiavellian about it, but that's the main reason. Another reason that maybe is a little bit more legitimate is, in a lot of, and this is an area that I feel kind of uncertain about what the answer should be. In a lot of areas where there's new innovation, and software is clearly one of our most innovative industries that we currently have, liability rules restrict innovation. They make companies worry about what they're doing, right? And especially if you think that not all of the greatest software we've ever had is made by, in fact, maybe very little of the greatest software we have is made by the Microsofts of the world. We also have great software that people use that's made by communities of people on open source, or that might be written by like a single person. And so there's some worry about or concern about how to impose fair responsibilities on vendors or coders, and yet also not cramp their style when they're trying to make something new. So, there's always been a lot of proposals about, imposing kind of some sort of tort liability on people who sell you crappy or insecure software, and that hasn't gone anywhere, mostly for the first reason I said, but I also think it's a little bit more delicate of a question of like, when is it going to, how to do it in a way that's not too oppressive. So, I agree with you that it's a problem. I don't think that the answer is particularly clear right now. And so, we always have, particularly in the copyright realm, we civil liberties people are always like, let the software go out there. Let's see what happens with it. Let's not impose liability upon it too soon, right? That's the argument we made in Napster. That's the argument we made in Grokster. And look what peer-to-peer software has brought us. Peer-to-peer has brought us VoIP, which is awesome, and all sorts of other stuff like that. So we've tried to really, and that argument for me has a lot of play. On the other hand, I totally agree with you. The people who are in the best economic position to make sure that software is secure don't necessarily have any economic incentive to do so, and as a result, the polity suffers, our public network health suffers, and that's sort of untenable as well. So I'm going to move to this section. Any questions? Yes, sir, in the back. Well, I think the reason they're getting away with it is because courts don't understand software and the ways in which it's, the same and different as cars. And I think it's also because, everybody drives the car and wants it to be safe, but the judges don't understand, why software is important to all of us and why the network health is important to all of us. And, it's just, you get into this realm where you're sort of arguing by analogy, and it's what analogy did they buy? I think that we're on a path. I just think we're really early in that path to understanding and being able to figure out the ways in which to regulate and the ways in which to protect. Like in my Hewlett-Packard case where, the guy was basically a guy who fixed Hewlett-Packard computers, and they said, well, you don't have the code anymore, so you're not allowed to fix them. And he, went and reverse engineered the code. It was very easy. It's like you type in the code and You just change where it just make it always true. Yes, that was the right one, and you just use the same program that Hewlett-Packard shipped him with the servers when he would buy them, right? So it's, just not that big a deal. And I said, it's like you sell you a car with a big padlock on the hood. And they say, you can't take this car to, the guy down the block to fix it. You have to take it to Honda. And if you don't take it to Honda, then you've broken the law because you've accessed our engine, which is inside, or you've cut our lock. That lock stays and belongs to us. And I think any judge would think that that was insane, right? But that's just not the way that the court actually saw it. Hopefully, as we get, better educated, and I think to some extent we're beginning to see some thoughtfulness about this, that problem's gonna go away. Yes.
A little off topic. In my position, I deal with our legal group quite intensively, so to speak, and a lot of them are not as in-depth as you are in your electronic law, right? They perceive it, see it differently, right? How that old mentality, so to speak. So my question is, outside of law school, is there anything you know of that security professionals can do or can go to as far as a resource or class, etc., to keep us up to speed on these types of topics?
So the question is, what can security professionals do to keep up to speed on these topics? I think mostly with the intent of being able to communicate better with the lawyers who are like your in-house counsel people or that kind of thing. It's something short of the horror of going to law school and suffering through that ordeal. And, I think that it's hard, but you can, and especially in this area, because it's, sort of, you're grabbing from various areas of the law, various things that happen to be important to security researchers, right? Like this is, I talked particularly about IP. It didn't talk about the computer hacking law. I didn't talk that much at all about the DMCA. So, we have this whole kind of constellation of things, and I think it is hard to keep up. But there are, a bunch of, I don't know. Let me think about this a little bit and see what I think is a good resource for the law. This is why, when I wrote this chapter for the book, I was really happy about it. And then a lot of people said, well, you should write a book, like with all of this stuff in it, because people would find it really useful. And I was like, well, I'm starting a new job and I'm pregnant and, maybe I'm going to wait a little while. But every time I speak about it, I think, well, I should really do something like that. But let me think about it. I'll give you my card after and we can email. Okay, and then I can maybe post it for other people who are interested too. Okay, not to short shrift. I'm going to let this person who hadn't had a question before. Were you raising your hand? Yeah. Okay. Okay, is he bound by the EULA? This is a great question, and I'm going to give you like a totally arcane answer, and hopefully you're going to like it, or not like it, like you like how it is, and also feeds back into the question that the gentleman over here had asked earlier about licensing. So, if it's a contract, if the EULA is a contract, and I say, when I sell this to you, you promise you're going to do this stuff, and then I'll sell it to you. And then you sell it to the gentleman sitting next to you with the white hat. He's not in privity with me, okay? That's the legal term. I don't know him. He didn't agree to anything. He's not in privity to me. As long as you didn't violate the contract, you're cool. And he's not under contract with me. I don't even know that guy. He's cool too, right? Everything's fine. And then he, as the researcher, can do whatever research and reverse engineer and benchmark and whatever he wants to do because he's not in the contract with me. And I can't say, well, he promised, he didn't promise, right? But it could be the stick problem where when I do the license to you, it's not a contract, it's a license. I only gave you 10 of the 20 sticks of property that I had. So when you sold your software to the gentleman next to you, he only got 10 sticks. I still have the other 10 sticks. And I can go to him and I can say, this was under license, it wasn't a contract, you don't have the right to reverse engineer because I kept that stick. I never gave it to you. So he still can't reverse engineer because you didn't have the right to sell it to him. That right never went to him. You see what I'm saying? And this is one of the things why the theory, I know, and this is why I said it was arcane, the theory of the law is really important, of what is happening when we make a sale. Am I selling it? Am I selling it with a contract? Is the contract enforceable? Or is it a license? And, how is the law kind of dividing up this bundle of sticks? And that is a question, that's kind of what UCITA and that whole push in the early 2000s, I don't know what we call this century yet, but in the early 2000s was sort of about, and we kind of don't know. We don't know the answer. I think maybe one of the reasons we don't know is because everyone's afraid to find out. I don't want to know in case it's an answer I don't like, and they don't want to know in case it's something they don't like. Okay, so that's it. It's 12:30. I guess it's lunchtime. Thanks for coming and for listening for so long.